This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Mr. Todd Lutsky from the law firm of Cushing and Dolan. We call the segment Ask Todd because it's your chance to ask Todd your questions about your estate plan. Phone number here, 888-205-2263. That is the studio line to get in line to ask Todd your questions. Again, normally we can get through 2 to 3 calls, so do get calling because last week we had 4. Fourth person didn't get heard, and it was very, very sad. So we want to make sure that we get to you if possible. Again, 888-205-2263. That is the number to call to speak now with Todd Lutsky. One more time, it is 888-205-2263. Mr. Lutsky, how are you today?
I am never better. How are you doing?
Tough day yesterday.
Yeah, what happened?
Got fired from the pasta factory.
The pasta factory?
Yeah.
Why is that?
Made a few silly mistakes.
Silly mistakes?
Yeah.
I get it.
Yeah, it was a tough day, but we're bouncing back. Todd, let's talk a little bit about naming beneficiaries on IRAs specifically.
Yeah, that's a
niche topic, but I think there's some meat in this niche here.
Oh, yeah, a lot of meat.
Historically, the guidance that I've heard on IRAs and naming beneficiaries has been name individuals as beneficiaries on IRAs, don't name trusts or estates. Does that fit with kind of what the historical pattern has been?
Yeah, and I think starting with the historical pattern makes a lot of sense because for a very, very long time, the primary beneficiary rule of thumb, and even today a lot, the primary beneficiary rule of thumb is surviving spouse.
Yep.
So that's what you would go with, generally. And then over time, and it's been going on now for a while, that if you've done your estate plan and you still would name the surviving spouse the primary beneficiary, but your contingent beneficiary might be your family revocable trust. If you want to ensure that the assets ultimately flow through a trust, and when you would do that is if your revocable trust has language in it that says, I want to protect my children from future divorces and future creditors, and maybe they're not great with money or whatever reason you're holding assets in the trust. Remember, when I say assets in the trust, all of your other estate planning assets are in the trust already, but not your IRA. But let's say you have, $1 million IRA. Well, you might not want to say, I've got my trust over here with another couple million in it of assets protected for my kids. I got $1 million IRA not in there. Maybe I don't want to list the kids as the contingent beneficiary because then it will come out to them directly over 10 years. I get it. That's the new rule. But the point is it's coming out to them, not protected, not sheltered from creditors, not, and so if you're saying, I really want to make sure that those assets find their way to the protection of the trust for the kids, then the contingent beneficiary should be the trust. Okay, so that's been sort of the evolution, and that's for people who've done revocable trust planning, never mind irrevocable trust.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question that you'd like to ask Todd during this segment here, studio line is open at 888-205-2263. That number again is 888-205-2263 in order to chat with Mr. Todd Lutsky. One more time, it's 888-205-2263. Todd, is there anything that you can do in terms of beneficiaries or contingent beneficiaries on IRAs that impacts how they're viewed from a Medicaid perspective, or are you still kind of in a tough spot with that and there's not much you can do?
Well, it is a tough spot generally, but now with the Secure Act 2.0 that I believe came out in about 2022, seemingly getting to be long ago, but You can name the estate the beneficiary, but there's a lot of rules you got to follow. You would generally do it only if you're a married couple, number one. And you'd kind of want to be 73 to do it. And then by naming the estate the beneficiary, which is, remember, as you said, the IRAs are assets I cannot protect in advance from the nursing home generally. But if you qualify, you can name the estate the beneficiary, and then you can protect these assets from nursing homes for the surviving spouse. And the real key is without a 5-year waiting period. Huge.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Again, if you've got a question for Todd, studio line is open at 888-205-2263. Still have a little bit of open space there on those lines. So please, if you got a question for Todd, this is your chance to ask him that question. Again, 888-205-2263. We're going to go to a quick break here, but it's right to your questions when we return. That number again is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, Todd, we got callers lined up for you. Let's get to them with Paul in Sandwich kicking things off. Paul, you're on with Todd Lutsky.
Hey, good morning. How are you?
Good morning.
Can you help me understand, if I set up an irrevocable trust and the beneficiaries are my children who are married, what, God forbid that the marriages don't last, but in this day and age, a lot of marriages don't last. What rights do the spouses or ex-spouses have?
So this is a great question because it applies, and I want to answer it for a lot of listeners. So I'm going to expand the answer to include not only irrevocable trust, which is what you asked for, Paul, but revocable trust. So I don't care if you've done revocable trust planning or you've done irrevocable trust planning. I always tell people, sheltering assets for estate taxes and probate avoidance, all that is important, but that's kind of the noise, right? The family behind the estate plan is really why we're doing this. And that is when you pass away, you can actually control the assets as to how they get to the beneficiaries. In this case, protection from future divorces. And so you put language in the document that does that. And basically, in a nutshell, to answer your question is, they will have no right to the assets when the divorce comes. So I'll just tell you how it works. Quickly, you put language in that says, if it said, I divide my assets equally to my kids and I give it to them, well, then you can imagine that 5 years later after you're dead, when the divorce comes, whatever you gave your children is now going to be gone, or is going to be cut in half on a good day, subject to that divorce. And it does happen. By not giving it to them, and I'm going to sort of put the pen back here into the trust bucket and hold it. If you hold it in trust, you put language in there that says things like, your kids can be trustee. Your kids can have the power to appoint a disinterested trustee and even remove and replace the disinterested trustee, so no problem there. But language says that when distributions come out, the only job the disinterested trustee has is to authorize distributions to that kid or to that kid's kids, your grandkids. And so your child as general trustee is doing everything, and the disinterested trustee is doing very little. But, every time the child says, we're going on a family vacation, we're taking a family trip, we need a car, whatever, the disinterested trustee authorizes the distribution. Now the child, 5 years after you're dead, gets a divorce. And the surviving, the soon-to-be ex-spouse says, I want half of what's in that trust we've been taking money out of over the last 5 years. And your child says, that's a really great idea, but you got to ask the disinterested trustee. Oh, see how that works. It's protected. And it's not just protected because the disinterested trustee can say no. Think about it from an ownership perspective. From an ownership perspective, the individual, your child, never owned what's in that trust. So if they don't own it, it's really not a marital asset to begin with. So you simply tell the other side that it's not a marital asset, so no, it's not available. So really provide some great protection, and that can be in a revocable trust or an irrevocable trust, because remember, once you die, all trusts are irrevocable. Now, folks, speaking of that, that's one way to protect assets. One of the assets that's tough to protect is an IRA, and that's why we're doing a guide. In this case, to go to Paul's situation, by naming the trust the beneficiary of the IRA, the trust, at least then it would be protected from these future divorces that I just discussed. So naming the kid outright might not be the way to go for everyone. In addition, folks that specifically want to add nursing home protection to their estate planning and are married, and there's a lot of other restrictions, you can learn how to name your estate the beneficiary of the IRA, which, as Chuck mentioned earlier, is very much outside the norm. It will it will allow you to shelter assets from these IRAs from estate taxes. It will allow you to not have any adverse income taxes, and without a 5-year waiting period, can protect it from the nursing home. But you need to couple it with a testament of trust. Get the guide, folks. Learn how to do it with your IRA. 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another caller for you here. Let's go to Jerry in Nahant. Jerry, what is your question for Todd?
My question is, I own a lot of real estate, and everything's in LLCs. So
Good.
Each individual warehouse or buildings I own are in LLC. So now I'm at 54 years old, and now I got to get a trust, or a revocable trust, some type of trust, a team together that can put this together. Unfortunately, I'm either between $10 million in real estate or over. On the assessed values, I could be up to 10.
Sure.
So I don't know how to, number one, tax defer some of the situation that I have, put everything in a trust because I'm at 54 years old now. And
are you married?
60 and 6 years. I'm married. I have 5 kids. So I've been listening to you guys for a while. I really think that you're the right choice. I just need a team of tax, lawyers, and everybody else that can put this together. And
well,
I don't know nothing about it. I just know that I do real estate and I collect rent, and that's my job.
I can tell you certainly that we have, you need a lawyer for sure. You need an estate planning attorney with that kind of an estate and married and 5 kids. So who you pick, up to you, but certainly, one, you need one. 2, yes, an estate plan to help you shelter. And again, remember, folks, the federal estate tax exemption is going to drop to about $7 million in a year and a half or so. So, $10 million, you're looking at 50% estate tax on the amount over for federal and state. So there's a lot of money right there. I love, Jerry, the fact that you have that you have LLCs in place for your real estate, right? That is really a great idea. But now you need to take the shares of the LLC and put them into probably a revocable trust. Whether you can get away with a joint or not would really need to sit down and learn about the size of your estate, whether we need 1 trust or 2. So we'd take the LLC shares, put them in there. You would always be able to then, and we put your other assets in there. And I will look at your LLCs and see if there's a way to, sort of fine-tune how you own those a little bit. But yes, I think an estate plan is in order to get your shares in there, to get your other assets in there, and then structure it to really eliminate your federal estate tax completely, and then significantly reduce your mass tax while also providing for your family, and maybe even with an estate this large, protecting those 5 kids from their future divorces and creditors, etc. I would certainly want to do that.
Todd, I've got one more for you. Let's go to Peter in Worcester. Peter, we've only got about a minute and a half, so we got to speed run this one a little bit. What's your question for Todd?
All right, Todd. Thanks for taking the call. Hey, listen, I set up a trust about 5 years ago. I'm retired, state employee, I'm retired police officer.
Is it an irrevocable trust?
It's a revocable trust.
Got it. Go ahead.
My 2 daughters are 23 and 26, and I'm looking at right now. I haven't looked at again. I have a 457 with the state that I started way back when in the 80s.
Yep.
There's probably about $1 million in there.
Yep.
And that's going through.
What's the question? Get right to the question. What's the question?
Okay. Here's what I want to do. I was thinking about making my oldest daughter the trustee, and I don't know if that's a good idea.
Okay. Well, it can be. When you mean when are you married?
I'm not. I'm divorced.
So when you pass away, I don't want the trustee to be your daughter now. You should be the trustee because it's a revocable trust, and then when you die, you certainly can have your daughter as trustee. That's not a problem ever. If, on the other hand, based on as you get older, you want to do irrevocable trust planning, it's also not a problem to have your daughter as trustee, but you don't have to have a daughter as trustee. So you need to think about that. So if that's the question, no real problem there.
Todd, thanks so much for joining us today. We appreciate it.
Thank you. Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.